All right, I'm going to make that happen, okay?
Okay, thank you so much, Judge. I really, really appreciate you.
Oh, you're so welcome.
Thank you.
Hello.
Hello, hi, ma'am. Good morning. Good to see you again.
You too.
Thank you.
Right. Miss Saucedo, we're going to
Yes,
go
ma'am.
on the record, all right?
Okay.
Court is calling 2022 CR 9121A State versus Justina Sauceda. Are you Miss Sauceda?
Yes, ma'am.
I'm just going to ask a few questions
Okay.
of you. It has absolutely nothing to do with the facts of your case, all right?
Okay.
Could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. So someone is here from Managed Assigned Counsel. Your attorney has been asked to appear, and I understand that there are some issues with his appearance.
This is serious. A suspended attorney cannot legally represent anyone. If this isn't handled correctly, it could trigger constitutional issues and even overturn future proceedings. Watch how carefully the judge responds here.
Suspended.
Right.
So that means that he cannot practice law. However, even though he cannot practice law, the cases where he's retained on, even the cases that he's appointed on, he really should inform the court so that if you want another attorney, you can have another attorney so that you can be updated on your case. You understand?
Yes, ma'am.
So he's suspended. So what that means is at this point in time, he's not allowed to practice law.
Yes, ma'am.
Now, I can do one or two things.
Okay.
One, I can ask that an attorney be appointed to represent you, or if you would like, you could retain another attorney. Do you understand?
Okay, yeah.
So do you want to retain another attorney? Do you want an attorney appointed to you? What would you like to do?
Well, I spoke to my mom yesterday when I got back to my unit,
Mhm.
and I think we're trying to see if there was any way I could get a court-appointed attorney.
All right. So what we're going to do is Managed Assigned Counsel is going to make sure that you have a court-appointed attorney.
Okay.
We'll make sure that you have someone to talk to today. All right?
Okay, thank you so much.
You're
So, I'm sorry. So is it okay to speak?
Yes.
Okay, so when I got back to my unit and spoke to my mom, she talked to a clerk and kind of like sort of what you were telling me. She found out that my attorney is not going to work for the law firm anymore, and that he dropped my case. So that's why we were wanting a court-appointed attorney.
All right. I'm going to make that happen. Okay.
Okay, thank you so much, Judge. I really, really appreciate you.
Oh, you're so welcome.
Thank you.
Your Honor, I do believe she has to be interviewed by a preacher.
R 008298 State versus Jonathan Gadina. Can I have parties announce?
Defendant for the state of Texas. David A. Garcia, attorney for Jonathan Godina, Your Honor.
And are you Mr. Godina?
Yes, Your Honor.
Am I pronouncing that correctly?
Yes,
All right. Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Godina, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor.
We are proceeding on the lesser included misdemeanor offense of indecent assault. Here's the shift. The state is backing off the original charge and moving to a lesser offense. That usually signals negotiation, evidentiary concerns, or a calculated plea strategy. This is where cases quietly change direction.
We are proceeding on the lesser included misdemeanor offense of indecent assault.
Any objections?
No objection, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, the state is proceeding on the lesser included offense of indecent assault as a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes, Your Honor.
Just one moment. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, and he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, and he is.
Mr. Godina, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed under indecent assault at 365 days. There's a $1,500 fine. There are no applications, and there's to be no contact with the complainant. Did you understand that to be your plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial? Sorry, did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
They've been filed but not heard, Judge.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. This time, state all offensive evidence. It's exhibit 1 of all attachments.
We've reviewed states one and all attachments, Your Honor. We have no objections.
All right. And state, have you spoken with the complainant?
Yes, we have, Your Honor.
And are they aware of this?
There you are.
All right. In an agreement?
Yes.
All right. Thank you. All right. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consent to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
All right. And I wanted to let you know the reason why I wanted to know whether or not the complainant was in agreement with this, because after reviewing the stipulations, I was inclined not to accept this agreement.
Yes, Your Honor.
That line carries weight. Even when both sides agree, the judge is not required to accept the deal. Judicial discretion is the final gate, and sometimes it's the most unpredictable one.
All right. The court will sentence you to 365 days in the Bexar County Jail, give you credit for any time served. There's a $1,500 fine, and there's to be no contact with the complainant.
Judge, we'd ask that money and time to run concurrent.
I will not do that in this case. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right. We can go off the record. Here's the thing. I look at the stipulations. I go by what the stipulations, right, are presented to me. So in this case, what's in the stipulations are what you stipulated to. You're saying that those are true.
Judge, we pled no contest.
But you pled no contest, but you all didn't.
We pled no contest to the charge of indecent assault, Judge.
No, I'm saying you pled no contest, but it says here that the defendant and they both style and number calls who being by me duly sworn acknowledged that he read or had read to him the foregoing waiver, consent to stipulation of testimony and stipulations. So if your intent was to do a no contest plea throughout, then you should put the no contest part there as well. So would you like to do that?
Yes.
So in the stipulations, do you have any daughters?
No, ma'am.
All right. So do you have any sisters?
Yes, Your Honor.
And obviously you have a mom.
Yes, Your
How would you feel if this were to happen to one of them? So it's at the top where you say, you see where you wrote, do not contest.
The documents are
And then
not contested.
And then right at the top, it says contest. Let me point it out to you. And just put there, not contested. All right, is there anything else? If not, you're excused.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
You're welcome.
Let's summarize today's cases. The courtroom moves fast, but the tension is unmistakable. First, the judge discovers a serious issue. The defendant's attorney has been suspended and quietly dropped the case. The judge steps in immediately, making sure the defendant isn't left unrepresented. No games. No confusión. A court-appointed lawyer is ordered on the spot. Then the tone shifts. Jonathan Godina steps forward, facing an indecent assault case. The state downgrades the charge to a Class A misdemeanor, but the judge makes it clear this is still serious. 1 year in jail, a $4,000 fine possible, and no taking this lightly. Rights are read. Consequences explained. There's no confusion, no pressure, no excuses. Godina pleads no contest. After reviewing the evidence, the judge hesitates, clearly disturbed by what's in the stipulations. Despite that, she follows the plea agreement and delivers the sentence. 365 days in jail, a $1,500 fine, and strict no contact with the complainant. No leniency, no reduction in time or money. Before ending the hearing, the judge drives the message home, asking him to imagine if this had happened to his own family. Court ends with one truth made painfully clear. A plea deal doesn't erase accountability, and the judge will not soften the consequences.